Oyez, oyez. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court. You may be seated.
Good morning. Before we call the docket, our apologies, because I understand the docket that was sent out by mistake said that this would be like, in other words, we sent out our Zoom docket from back from COVID time, so I'm glad everybody's here. Call the first case, please.
24 Hour Home Buyers, LLC, et al. Versus Lewis Roberts, et al.
We'll hear from the appellant when you're ready.
May it please the court, I am Thomas Levier. I'm the attorney for 24 Hour Home Buyers and Nathan Jackson, who are the appellants in this case. I request that I be allowed to reserve 3 minutes for rebuttal, please.
That'll be fine.
Thank you, Your Honor. The facts, or the underlying facts of the merits of this case are relatively straightforward and simple. The case involves a purchase and sale agreement for real property here in Knox County, Tennessee. My clients were not both of my clients, but 24 Hour Home Buyers was the purchaser under a purchase and sale agreement that was entered into in January of 2020. The purchase price for the property was $1 million. The closing was to be approximately 11 months later, and there was a provision in the contract that allowed the purchasers a period of time within which they could entirely cancel the contract. About 3 months later, in March of 2020, there was an amendment to the contract. And the primary amendment, there was some other minor amendments, but the primary amendment was to reduce the purchase price to $637,000. This was before the time period for the cancellation of the contract had passed. Under the circumstances, the 24 Hour Home Buyers moved forward with attempting to purchase the property. Still had several months to go before the closing on the property was to occur, and was moving forward towards closing. Within a couple of months of the amendment to the purchase agreement, 24 Hour Home Buyers received a letter from the defendants canceling the contract and indicating that there had been misrepresentations that were made in relation to the contract. As the case later proceeded, the primary misrepresentation that was identified by the sellers of the property is that they have claimed that even though there was nothing in the written documents, the written agreements between the parties, the defendants have claimed that the 24 Hour Home Buyers and Nathan Jackson, who was later brought into the action, had agreed verbally, orally, to locate and to purchase some separate real property. And the claim of the defendants in that relation is that that was the purpose, that was the reason for the reduction in the price. Closing never occurred, obviously. Litigation ensued, and the case proceeded through the litigation process for over 2 years. Those are the basic facts of the case, relatively straightforward. The procedural issues are what have led us to where we are today. There were a number of discovery issues that were addressed to the Chancery Court, and one of the issues, or the primary issue that ultimately led to what happened, was a request for production of documents that came from the defendants to the plaintiffs in the year 2020, and excuse me, I may have stated that wrong. I think it was 2021. But in any event, they asked for tax returns from the plaintiffs. Those tax returns were not produced, and an objection was raised to them. Approximately a year later, and shortly before the trial, so this would have been in October of 2022, and shortly before that, there was There was a deposition that was scheduled of 24-hour home buyers and a deposition that was scheduled of Nathan Jackson. And in that deposition, Mr. Jackson was asked to produce the tax returns. And the tax returns were never returned. Long story short, there was an order from the trial court that indicated that the tax returns should be disclosed. The order was not complied with. The order was, the tax returns were not disclosed. The defendants filed a motion to strike and a motion for default judgment to strike the answer, and then motion for dismissal of the original countercomplaint. Those were granted by the trial court in October of 2022. Ultimately, judgment went down after the default was granted, and that was granted in December of 2022. In
When was the statement made, or was it a response made that they can I can bring them to trial or something of that nature?
That was correct. There was a hearing that was held, and Mr. Nathan Jackson testified in that hearing. And my best recollection of the date of that hearing would have been, I think, October 28th of 2022. And in that, Mr. Jackson did say that, yes, I can bring those to trial. The trial was scheduled, I don't remember the exact date, but sometime in the immediate future after that hearing date. The trial court did not accept that proposal, and the sanctions were then granted.
So they could be produced, but he just didn't want to produce them then, or what?
Well, I guess the answer on that is not entirely clear why he didn't agree to produce them. But the bottom line is he didn't produce them. We don't have an argument that he did produce them. We don't have an argument that he complied with the order of the court. But the argument that we are presenting is that it was an egregious sanction, and the sanction itself was not warranted. Now, the problem was that there was no Rule 59 motion that was filed. It ended up being a Rule 60 motion. So after the judgment became final, it was submitted as a Rule 60 motion. And at that point, 24-hour homebuyers and Nathan Jackson presented evidence in the form of an affidavit with documents attached saying that they had discovered new evidence that they were not aware of at the time that the order was entered in October of 2022. That new evidence is...
Mr. Levier, what does the discovery of the new evidence have to do with the failure to provide the tax returns, the basis for the granting of the dismissal?
Well, in and of itself, the answer to that is it doesn't necessarily have anything to do with the granting of the sanction, other than twofold. One, these documents that were attached to the affidavit of Nathan Jackson totally undermined the defense that was raised by the defendants and supported their counterclaim. So that's number one. Number two, as it turns out, the defendants were asked about these issues in discovery, and they did not produce these documents. So in other words, the defendants were guilty of the exact same thing that they were accusing the plaintiffs of, and that is not producing relevant documents in discovery.
Well, it wasn't quite the exact, excuse me, the exact same thing, wasn't there? Was there a court order down as to Jackson?
There was not a court order.
Ordering him to produce it?
There was not a court order them to producing it. And it wasn't, the existence of them wasn't even discovered by my client.
No, I'm talking about the documents your client didn't produce.
Oh, yes, there was an order that said that he had. So
that's a different situation, isn't it?
It is a different situation, yes, from the standpoint that
And he never did provide a reason why, or did he ever provide a reason why he just didn't produce them?
Well, there was a hearing, and...
But did he ever was there ever a reason presented to the trial court, here's why we didn't do it?
Well, his reason that he stated in the hearing was that he couldn't locate them, didn't have immediate access to them, and couldn't immediately produce them.
But he could produce them at trial.
That is what he said. Now,
Okay.
I'm not trying to argue before the court that he didn't do something improper there.
I understand. I'm trying to figure out why you say where the trial court erred in not later granting the motion.
Well,
Let me be a little more specific here. Was there anything in this motion reflecting any reason why he didn't comply with the court's order?
that was not the basis of the motion,
Okay.
no. Now, what we say is that if the court had been aware of these same exact issues back in October of 2022, one, the failure of the defendants to produce these documents, and it goes beyond that. There were statements that were made by one of the defendants when she was asked about these documents in her deposition, and I don't know if I can put my fingers on here it is. She was asked how she went about searching for a new home. Now, again, the important part of this is that the defendants had always maintained that they had an oral agreement with Mr. Jackson and with 24-hour home buyers to go out and locate a home, and that was the whole reason for the reduction of the sale price. And so she was asked about in her deposition how she went about searching for a new home, and she said the internet. And then she was asked, and at any point, did you use the services of a real estate agent or realtor? And her answer was no. And there's more to that, but the point of the Rule 60 motion that was filed was if the trial judge had been aware of, one, the failure to produce these documents, but two, the false testimony in relation to whether they had hired a realtor or not, that is evidence that would have been relevant and could have been part of the ultimate determination of the trial court.
Did your client explain why it just newly discovered this evidence?
He says he just simply was not aware of it.
Well, but did he explain why? Oh, look, we found this evidence now, but we couldn't find it earlier.
Yeah, well, what his, as I understand his testimony was in his affidavit was that there was another individual, another realtor named Dustin Weaver that was involved. He did not realize that this particular individual had any knowledge that was related to this other realtor that ultimately had the contract with the defendants and had ultimately communicated with him. And he simply did not have knowledge of it, and he had
Did he explain why he was able to get knowledge of this after the court's order went down, but couldn't get knowledge of it before the court's order went down?
Well, the answer to that is communication with Dustin Weaver is where
So
he
he
got.
didn't explain why he couldn't do this before.
But he did not know that
I understand.
he did not
But
have knowledge of
I
it.
understand. He didn't have knowledge until he found it.
And he asked about it. So he asked about it in discovery. I see my time's up, but.
That's okay. You can finish
Well,
up.
I think the answer is he did ask about it in discovery. He asked for documents. He asked in depositions. And the answer was no, this didn't happen. There was none of this evidence. So he didn't have a basis for going and searching this evidence out. Thank you, Your Honor.
Okay, thank you. You have your time for rebuttal. We'll hear from the appellee.
Good morning.
Morning.
May it please the court, my name is Rebecca Harbin, and I, along with Mr. Grossman, represent Lewis Roberts and Angela Roberts, and they're here in
Would
the
you-
court today.
Excuse me, can I pull a microphone over?
Sorry,
kind
is this
of in front
better?
of you? Yes.
Okay, thank you. So this appeal solely concerns that Rule 60 motion that Mr. Levier discussed earlier. He mentioned that the egregious nature of the sanction under Rule 37 for the underlying judgment was at issue in this appeal, but respectfully, it's not. It is only the denial of a Rule 60 motion by the trial court. But for context, the background facts are a little bit important here. So, as alleged in the counter-complaint and third-party complaint against 24-hour home buyers and the third-party defendant, Nathan Jackson, Lewis Roberts entered into a contract with 24-hour home buyers in January of 2020 to sell 4 parcels of property for $1 million. Following the date of that contract, 24 Hours and Nathan Jackson both represented to the Roberts that they would buy a different property if they agreed to equivalently reduce the $1 million purchase price. And the Roberts have alleged a very specific property at 1145 Yosemite Drive in Lenore City. Mr. Roberts agreed to this proposal, and the parties executed an amendment reducing the contract price. Eventually, it became very clear that Nathan Jackson and 24 Hour Home Buyers did not intend to buy them a house, as he had promised in exchange for the reduction, and so they terminated that contract on the basis of fraudulent inducement. This lawsuit ensued, and the Roberts filed a countercomplaint against Nathan Jackson and 24 Hours for, among other things, fraudulent inducement and violation of the Tennessee Consumer Protection Act. And so even though the underlying judgment isn't really at issue in this lawsuit, it's important to understand the procedural context of what actually happened. So I will briefly address that. In October of 2022, after the appellants had filed 3 motions to continue the trial, but the last of which was denied, the Roberts filed a motion for involuntary dismissal and to strike the answer of the appellants to the third-party complaint and countercomplaint pursuant to Tennessee Rule of Civil Procedure 3702. The Roberts stated as grounds for that motion that the appellants had failed to appear to a properly noticed deposition in October of 2021, that the appellants had committed instances of perjury during their June 2022 deposition, and that they had violated an order to compel production of documents entered by the trial court on October 18th, ruled by the trial court on October 18th, 2022, but entered on October 28th, 2022. And this was an intentional violation by the appellants. The appellants were not just ordered to produce tax returns. They were told to produce communications with third parties, contracts with third parties, bank documents, and tax returns. And they agreed to produce them during their June 2022 deposition and failed to do so. So on the date that the court had ordered the production of all of those documents, they did produce one document. And during a supplemental deposition, the appellants testified that they only produced that document to prove their own damages. Then during the hearing, as the court identified during Mr. Levier's argument, Mr. Jackson did testify as to the reason that he did not produce those documents. And Mr. Jackson testified as follows. It would have, been adequate and, not in my favor, obviously. So yeah, and that's the technical record, volume 11, technical record of evidence, volume 1, page 25, 5 through 17. And so the reason he did not produce those documents was because they weren't in his favor. In any event, the parties appeared for that hearing on the Roberts Rule 37 motion on October 31st, the day before the set date for the jury trial. At the hearing, the appellants then counsel, their second counsel to appear, offered their client to testify as to their failure to comply with the orders of the court. The appellant's counsel represented that he struggled with the ethical obligations of his duty of candor to the court and his attorney-client confidentiality because of the reason that Mr. Jackson and 24 Hours had failed to produce the documents. The appellant stated that the documents just wouldn't have been in their favor, but he supposed he could get them for trial if necessary. And this was notable because the Roberts had been seeking these documents for 1.5 years, and the trial was set to begin the very next day. The trial court issued a memorandum opinion at that hearing where it found that the appellants were not credible, that they had violated both the discovery rules and the order of the court, and it entered a judgment by default against them and dismissed the original complaint. In January of 2023, the appellant's third lawyer filed a motion for relief from the judgment pursuant to Rule 60, and that's the motion that we're here today. They argued that they're entitled to relief because the Roberts withheld evidence, because Miss Angela Roberts committed some instance of perjury, although the record does not reflect that there was ever any determination as to whether that's true, and that their attorney's lack of preparedness was excusable neglect. Following a hearing, and by the way, the transcript of that hearing does not appear in the record on appeal, and so the only order of the court or record that we can consider is just the order following the hearing. The trial court found as follows. The trial court finds that the movements have failed to present the court with clear and convincing evidence for any of the three bases upon which they have moved the court to grant relief as required by Tennessee Rule of Civil Procedure 60. Moreover, the court finds that none of the newly discovered evidence was admissible for purpose of Rule 60 relief, and the court finds that none of the evidence provided by the movement are material insofar as it would not have altered the decision of the court in October 31st, 2022. Accordingly, that motion is denied. And the appellants have now appealed that order. So, as this court is aware, relief under Rule 60.02 is an exceptional remedy designed to strike a balance between competing principles of finality and justice. Relief under Rule 60.02 is not meant to be used in every case which the circumstance of a party changes after the entry of a judgment or order, nor by a party who is merely dissatisfied with a particular outcome. A party seeking Rule 60 relief must substantiate that request by clear and convincing evidence. And clear and convincing evidence means evidence which there's no serious or substantial doubt about the correctness and the conclusions drawn from that evidence. So the bases for this current appeal, the appellants first argue that the trial court erred in not conducting an evidentiary hearing on the Rule 60 motion. And this statement is not supported by the record at all. There is no transcript of evidence for this court to review whether or not the trial court conducted an evidentiary hearing at all. It may have, it's just simply not contained in the record.
Did the trial court's order reference an evidentiary hearing?
It did, Your Honor, and it said that none of the evidence was admissible. And so based upon the order, you would have to assume that an evidentiary hearing occurred if the court made that determination. Yet the appellants contend that the court didn't have any evidentiary hearing.
Did the court's order reference anything about any witnesses?
No, Your Honor, they did not reference any witnesses that appeared.
Okay.
Thank you. And so because it's incumbent upon the appellant to include a transcript of evidence to preserve the issues for this court's review on appeal, they've waived the issue as to whether or not the trial court erred in failing to conduct an evidentiary hearing, if in fact that's true, which is contradicted by the order, which provides that it did make a ruling as to the admissibility of the evidence that the appellants presented at the hearing. They've also waived this fact insofar as, because there's no transcript, we cannot determine if they ever even requested an evidentiary hearing. And for that reason, they've waived the argument that the trial court erred in failing to conduct an evidentiary hearing on the Rule 60 motion. And just briefly, and although it's not necessary due to the waiver, the trial court also did not abuse its discretion when it determined that none of the newly admissible evidence or newly discovered evidence is admissible. That evidence consisted of an email communication between Angela Roberts and another realtor, and a contract between the Roberts and a third party not involved in this lawsuit. The appellants only submitted the affidavit of Nathan Jackson, but Nathan Jackson lacked that requisite personal knowledge to authenticate these documents under Rule 901 of the Tennessee Rules of Civil Procedure. So the trial court did not abuse its discretion when it determined it could not consider those documents as a basis for Rule 60 relief. And
your client, had appellant requested any such documents during discovery from your clients?
Your Honor, we didn't request, they didn't request it from us, but we did subpoena Dustin Weaver, who was the person who eventually produced those documents, trying to get those documents. We were trying to find them because we thought, even if it hurt our case, we need to obtain everything that we possibly could. Dustin Weaver did not give us those documents, and the record will reflect that Dustin Weaver is an agent of the appellants. So after he received the subpoena where we were trying to get those documents, he failed to respond to it. And so we subpoenaed him well before the October 31st hearing. And so we would have produced it if we had it. We tried to get them, and we were unsuccessful in doing so.
I understand what you're saying, that the trial court found the document was inadmissible, but if it, put that aside for a second, your client didn't have a copy of it?
No, Your Honor. For whatever reason, we didn't have it, but we were trying to find it by issuing subpoenas. We also issued a subpoena to the Knox Area Association of Realtors to try to find those documents. We issued a subpoena to DocuSign to try to find a contract that may have been signed by our clients. They just didn't have it. And so we were trying
Did
to
your
find
clients
it.
say there was no such contract?
They did not say that. We were trying to find that.
I understand, but I believe it was her deposition, did she say that there was no such contract? They had no agreement with any other realtor?
She said that she went on the internet and that's how she found this house. And then they asked, did you communicate with any realtor beside listing agents? And she said no. And the record would reflect that the person she communicated with was a listing agent.
Okay.
That was the
So
specific.
they asked, the question asked to her was about other than a listing agent?
Yes, there was that qualification in the question. Thank you. The appellant's next assignment of error is that the trial court failed to make adequate findings and conclusions in its order denying the Rule 60 motion. And the appellants rely solely on the Howard versus Howard 2023 case that came out of this court and also out of Part 2 of the Chancery Court for Knox County. And I would note that the chancellor who is ruling on this case is a different chancellor than presided over the Howard case. But in that case, the chancellor indicated following the hearing that it expected subsequent briefing and another hearing on the Rule 60 motion, and that's not what happened here. In that case, the chancellor, their full opinion said, or the full order said, this cause came to be heard before the court upon plaintiff's verified motion to set aside attorney's fees provision of the final judgment for divorce. After argument of respective counsel and review of the record as a whole, this court finds the plaintiff motion shall be denied. And that's completely different than the order that was ultimately entered by the trial court on the Rule 60 motion. Here, the trial court made specific evidentiary findings. It determined that clear and convincing evidence was not presented to it, and it also determined that the evidence was not material because it would not have changed the outcome of the October 31st, 2022 hearing. This is a thorough finding and conclusions contained in that order. Finally, with respect to their attorney's lack of preparedness as a basis for excusable neglect, Tennessee does not recognize an attorney's neglect as a reason to grant Rule 60 relief. As this court cited, or the middle section of this court cited in Brokerage Apartments versus Universal Constructors, if the lawyer's neglect protected a client from ill consequences, neglect would become all too common. It would be a free good. The neglect would protect the client, and because the client would not suffer, the lawyer would not suffer either. And so any neglect, if any exists at all, and we would contend that it does not serve as a basis for Rule 60 relief for the appellants. And finally, I think all other issues have been thoroughly addressed in our brief because the underlying judgment against the appellants is for a violation of the TCPA, which allows for recovery of attorney's fees. The Roberts are entitled to recover all of the fees that they've incurred on this appeal. And so we would respectfully request that the court affirm the ruling of the trial court with respect to the Rule 60 motion and remand this for an assessment of fees incurred on appeal. And if the court has any questions for me, I'd be glad to answer them.
I hear none. Thank you.
Thank
Hear
you,
from the
Your Honor.
appellant. Rebuttal.
Yes, Your Honor. If you look at the testimony of Angela Roberts, it's more detailed than what I quoted a few minutes ago, and it's more detailed than what counsel has indicated. There is one question that deals with listing agents, but there are other questions within the deposition itself. Specifically, she was asked, and at any point, did you use the services of a real estate agent or realtor? And she said nope. Then the question comes in about listing agents, which is a different issue. And then the questioning continues. And no one, your husband or yourself, did not enter into any agreements with a realtor to help you find a house. The answer was no. The next question, before the contract was signed, did you make any offers on any properties? The answer was no. The next question, did your husband make any offers on any properties? The answers were no. Those answers were not correct under the circumstances, and this evidence was not found by Mr. Jackson until later, until after the judgment had already gone down. I've already explained why we think that is that is an issue that potentially or should have changed the decision of the trial court going back to October of 2022. And the other issue I wanted to address is the admissibility of these documents and whether there was an evidentiary hearing. The appellees are saying we should submit a transcript to the record of what evidence was submitted to the court. There was no evidentiary hearing. The order of the court says it was made upon argument of counsel and the record as a whole, and that's it. There are no references to any witnesses testifying, nothing other than argument of counsel, and that's all it was, and that's why there's not a transcript of the evidence, so to speak. We did ultimately find out that there is a transcript, but it's not part of the record, and it doesn't involve the submission of evidence by the plaintiffs. I do want to raise just one more issue. I know I'm almost out of time here, and that's the authentication of these documents and whether the documents should have just been outright declined to be admitted into evidence. And I found a case, and I did not have this case when I drafted the brief or the reply brief. I've just found it while I was researching another case.
If you would, just send a letter to the court clerk and opposing counsel, just saying, here's the case referenced in the hearing. Don't argue anything about the case. Just give us the name of the case and the site.
Can I make a brief argument right
Yes,
now?
yes.
Okay.
Yes.
Well, this is what the case says. And it was in relation to a Rule 59 motion, but it said that the facts upon which plaintiffs rely to establish a meritorious defense to the motion for summary judgment must be admissible at the trial, but need not be in admissible form as presented in the motion. The case is Burge versus Warlick, and I'll submit it to the court. Thank you, Your Honor.
Court's thanks to counsel for both sides. We appreciate your briefs and your arguments on this. Call the next case, please.
Vicky